Morning.
Welcome to our Budget and Taxation Pension Subcommittee meeting for this morning. For the members, our agenda is in front of you today. Senator Michael Jackson. We have Senator Benson, Senator Alfred, Senator Salling, and Senator Bailey. We're going to start off with Senate Bill 695, Senator Jennings. If you have a panel, bring them up with you and proceed when you're ready, sir.
Good, how are you? Yeah.
See, you have the
Anna's with me.
A team with you. All right.
Thank you.
Proceed when you're ready.
All right. Good morning, Mr. Chairman, distinguished members of the committee. For the record, Senator J.B. Jennings, Senate Bill 695. This bill is pretty simple. It deals with service academies and members of the military who went to a service academy and does their time there go towards a state pension. As you know, there's 5 academies: U.S. Naval Academy, Air Force Academy, Merchant Marine Academy, Coast Guard Academy, and West Point. What this bill does is it allows those that attend these academies can earn up to 4 months of credit for each year they go to the academy, not to exceed 16 months for their final state retirement. It's a pretty simple bill. It's not going to be a huge fiscal note. There's not a lot of academy grads that have come into state government, but it is a way of saying thank you to them. This is very similar to legislation that we passed a couple of years ago that dealt with the National Guard. So it's pretty simple. I'll turn it over to Ann if she has any input she wants to give, or if the committee has any questions.
Ms. Gothard, do you have any
No, I'm
comments?
just here to answer questions. We've looked at, I think the Joint Committee has not really looked at this particular issue since the early 90s. The law has changed a lot since then, and we have no issue with the bill, and we appreciate the sponsor reaching out to us and working with us in the drafting of the bill.
All right. Any questions or comments from the committee? Hearing none, this concludes the hearing. Thank you.
Thank you.
Next bill will be Senate Bill 633, Senator Mouts. Employee Pension System, Purchase of Service.
Whoever's comfortable with Indra. Good morning, Chairman and committee members. It's an honor to be here. Thank you for the opportunity to present Senate Bill 633. I've got a brief introduction for this legislation. It was introduced last year, and we have taken it up again this year for reconsideration. Chairman, would you like me to introduce our panel? We have one witness panel, or will you do that?
You can introduce yourself.
Okay, thank you very much. Just a brief explanation. I'm going to read just an explanation for the committee so they understand this. In current law, a member may purchase credit for eligibility service for up to 10 years for periods of employment for which a member is otherwise not entitled to service credit. To purchase service credit, the member must pay to the Board of Trustees of the State Retirement and Pension System an amount to the annuity reserve and pension reserve required to fund the additional allowance. Membership in EPS terminates if a member, among other reasons, is separated from employment for more than 4 years. This legislation allows a former member of the employee's pension system who meets specified criteria to purchase eligibility service credit for past employment with the state for which the former member is otherwise not entitled to service credit. The details of how purchasing credit is contained in the fiscal note. I'm sure everybody in the committee is familiar with this. Our witness is a constituent, Ravindra Gavnir, said it correctly. I worked on that, has the specific details of why this proposal is needed, how it will benefit the retirement system, and particularly how it will benefit him. So thank you for my indulgence, and I'm going to introduce our witness now. Thank you, Chair, the committee.
Welcome. Sir, proceed. You have 2 minutes.
Slide over. Get right on.
You can just pull it close. You will have 2 minutes, and for the audience, the presenter of the bill can take as much time as necessary. Witnesses 2 minutes. So proceed, sir. Go ahead.
Good morning, Chair. Good morning, honorable senators. I thank you for giving me the opportunity to speak on behalf of Senate Bill 633. My name is Ravindra Ganvir. I'm a resident of Salisbury, Maryland. This bill would directly benefit me. I have worked as a contractual employee with the state of Maryland from April 1984 to December 1991. After that, I joined the Maryland State Service from December 1991 till March of 2009. Okay. This bill would allow me the opportunity to purchase my contractual service that would benefit me and my family. This is the year that I would need to retire, so there is some urgency in terms of getting this bill passed. Last year's Honorable Senator Eckert introduced the bill. It was a last minute addition, and I'm not sure exactly what happened after that. I do have some supporting letters from my previous supervisors who had worked with the state service for 42 years. He was retired as a district engineer, and he was my direct supervisor for 7.5 years of contractual service, along with a honorable council person from Wycomico County. I request the committee to give a favorable vote for Senate Bill 633. Thank you.
All right, Senator Benson.
Yes, good morning. Thank you very much thank you for the testimony. I want to ask 2 questions. So your contractual service that you're referring to is about 7 years?
Roughly 7.5 years plus.
And are you asking for us to consider you purchasing those 7 years?
Yes.
Perhaps you can answer this question. Who would set the amount of money that had to be paid for those 7 years? Who would make that determination?
That determination, from my experience, will be State Retirement Board. One of my colleagues, he had purchased his service while he was a state employee, and we had joined the state service same time, and he purchased about 7.5 years, and the rough cost was about $85,000.
How much money are we talking about? Do you have any idea?
I do have some computations for about $85,000.
How much?
$85,000. That was the cost for him to purchase the service, and mine would be in that range, could be plus minus, whatever the computations would come out to.
So you're talking about paying $85,000?
Yes.
If I might, Madam Senator, Ms. Gothrop, can you lend give us some general information regarding this matter?
I'm sorry, what do you need?
I'm to ensure that the committee is understanding the question posed by Senator Benson and the answer given by the panelists.
Why it's $85,000? You're asking why it's $85,000? The way the bill is drafted, I don't have it in front of me, but I think the purchase, when there are different types of purchases that members can make for service credits. Some are just strictly member purchases, meaning they just have to pay what the member would have put in their member contributions plus interest. So that could be 7% for however many years plus interest on that. Then there are some that, and I think that is this bill, this is a 50%. Yeah, so it's 50% member, 50% employer. This type of purchase contractual time. You have to pay 50% of what the member would have paid, plus 50% of what the employer would have paid. And that is the piece that's super expensive. That's what jacks the price up, plus interest on all of that for the time that has elapsed since
Ravindra.
has been in the plan, or has been out, the difference between the time when he left the contractual time and today. And the reason we need the employer piece is it needs to make the system whole. Otherwise, there's an unfunded liability. This is an unfunded benefit that he would get if he wasn't paying the employer piece. So it is very expensive. A lot of times, we had a lot of members ask for these types of purchases. They realize what it's going to cost and it's prohibitively expensive.
Thank you very much, Ms. Gothrop. Any other questions or comments? All right. Well, this concludes the hearing. Thank you, gentlemen.
Thank you. Have a wonderful day.
Next bill up will be Senate Bill 641, Law Enforcement Officers Pension System, City of Bowie Police Department Transfers and Purchases of Service. Ms. Gothrop, you probably don't want to go too far. Gentlemen, come on up and bring your panelists. And proceed when you're ready. I will begin. Let me back that up. So, sorry about that one.
Good morning, Chair.
I'm going to proceed. I'm going to start. And you guys are going to follow up. I'm sorry. It's my mistake. So thank you, fellow committee members. For the record, Senator Michael Jackson representing District 27 on behalf of Senate Bill 641. This is a very straightforward bill that simply allows employees of the Bowie City Police Department who are hired between January 1st. Are you okay, Senator? Welcome to the Senate of Maryland. All right. This is a very straightforward bill that simply allows employees of the Bowie City Police Department who were hired between January 1st, 2007 and December 31st of 2015 to transfer and or purchase their previous years of service credit from their time in another in-state police department. The legislation would create a 6-month window to transfer and or purchase said credits. The necessity of this legislation comes from some inaccurate information that these individuals received during their onboarding between 2007 and 2015. And we have some witnesses here to testify on their behalf, on that behalf. This is the bill that's simple. It's a simple effort to make these individuals whole and to get them their benefits from which they're rightly entitled. This is a technical fix that will make a huge difference for these officers and allow them and their families to receive the benefits that they are due. And with that, members, I will be asking for a favorable vote on this piece of legislation. And we have before us 2 members of the Bowie City Police Department. So gentlemen, proceed anywhere you wish.
Good morning. My name is Ryan Shiflett. I'm a current member of the City of Bowie Police Department. Prior to that, I was a Baltimore City police officer, which I started my career in 2005. I left when the City of Bowie started a new agency in September 2007 is when I got hired. Upon my initial hiring packet process, I was not given the opportunity to purchase my time. When I asked about it, I was told that you had to hold your money and purchase it on the back end. So the money that I had in the fire and police pension for Baltimore City was not allowed to immediately transfer over. So myself, along with under 20 of our members were affected by this. So our first member went to the retirement aid LEOPS and attempted to purchase his retirement. He had interest and penalties and extra fees that were added on, and in which case it didn't match with what the city had originally told us. So when I contacted LEOPS to find out what the issue was for our retirement, to make sure that it's squared away for when everybody goes in, I was told that the interest and penalties is because we didn't buy it on the front half. We were required to purchase it on the beginning. That wasn't offered to us when we asked about it, because it was a new agency, and I think it was a clerical error on their side. So, when speaking with them, they said we had to put the bill in to get it fixed. We have a letter from our agency to LEOPS stating that it was a problem back in 2012, but the members weren't notified of that. Just LEOPS was given a letter for one member when they recognized it. Thank you for your time.
All right, cool. Next.
Good morning. My name is Craig Matthew. I'm currently a police officer at the City of Bowie Police Department. I was hired in 2012 for the Anne Arundel County Police Department. I lateraled over to the City of Bowie Police Department in 2014. At the time, I was informed by our human resources during orientation in reference to moving my time on the back end. However, I never withdrew the funds from the Anne Arundel County pension system, and I left it in there till today, thinking that was the right thing to do, to just leave the money in there until it's time to buy it on the back end. However, since then, I was misinformed, along with several other officers, that you can't do it that way. You purchase your time up front for LEOPS. Since then, we do, like Corporal Shiflett over here explained, that we do have a letter that came from the department that said that there was an error and they recognized the error. And since then, I don't know how much correction they've made since then to rectify this issue, but as of right now, I would be losing out on approximately 2 years of service that I could be adding onto my time at the City of Bowie Police Department.
All right. Any questions or comments for this panel? Ms. Ann Gothrop, would you like to weigh in on this? I know you've had the conversations, but I think committee members, we have seen all too often some of these one-off circumstances where employees aren't giving correct information, and it's pretty much up to us to make sure we rectify that. So we will definitely take this under consideration and see what we can do about it. So thank you, gentlemen, for coming up.
Thank you very much.
Thank you. Concludes the hearing for 641, Senate Bill 641. Next up, will be Senate Bill 834, State Retirement and Pension System Administrative Fees. And I will begin. Thank you, fellow committee members. For the record, Senator Michael Jackson, representing District 27, and in my capacity as chair of the Joint Committee on Pensions, on behalf of Senate Bill 834. Senate Bill 834 comes to us by request and alters the method that administrative fees are calculated and remitted to the state retirement and pension system. Additionally, it requires the system to provide notice to local participating employers, and it makes a couple of other changes relating to the funding of expenses incurred by the Board of Trustees for the State Retirement and Pension System and the State Retirement Agency. To explain this more in depth, we have Ms. Ann Gothrop. Thank you. We're asking for a favorable report, obviously. Ms. Gothrop.
Thank you, Mr. Chairman. So Senate Bill 834 is board requested legislation that we asked the Joint Committee to sponsor on our behalf, the agency's behalf. It greatly simplifies our current process for collecting our administrative fees for the agency, and our administrative fees are how we pay for our budget. And administrative fees are charged to each participating employer. They have to pay a percentage based on their employees that participate in the plan. That's what they pay to the system for our budget. And this all begins with the governor's allowance. Whatever he puts in the bill for our administrative fees, when he introduces the bill, that is what we use to charge our participating employers based on their involvement in the plan. So from the very beginning, what we are, and we have to bill them, we have to certify this rate to our participating employers in February for the upcoming fiscal year in July. So in February, at that point, we already know that what we're billing our participating employers is not going to be our final appropriation in April, and it certainly isn't going to be what we spend throughout the rest of the upcoming fiscal year. So we know we are billing them an incorrect amount. And whether that's too much or too little, we have to track that difference for the next 2 fiscal years before we can recover it from all of the participating employers in the plan. In addition, we have to track with DBM any budget amendments that happen throughout the year. And we have to keep track of them for the next 2 fiscal years. And this is a really onerous process. So what this bill does is it eliminates all of that. And it says going forward, we will fund our administrative fees from the trust of the plan, but then reimburse the trust at the end of the year with the administrative fees that we collect. So it takes care of having to track any over and underpayments that we're receiving. In addition, instead of just giving the participating employers from February until July to budget for this. We're not going to be able to certify under this bill by October of the previous year. So they're going to have 4 additional months, and this will include the state to budget for this amount and plan for this expense for the upcoming fiscal year. So we would greatly appreciate your support on this bill.
All right, thank you. Any questions or comments? No questions or comments. Thank you very much. This concludes the hearing on Senate Bill 834. Next up, our final bill, we have Senate Bill 597, Senator Carter, pensions and retirement, forfeiture of benefits, law enforcement officers. Proceed when you're ready.
Good morning, Chair Jackson, members of the committee. I'm quite pleased to bring this bill. It's not the first time that some members of this committee have heard it. Welcome to the new members, and I think this is a very necessary and common sense bill. We did some incredible work on police reform in the 2021 session, but our work is really not finished. Not just with this bill, but there are several other areas that we simply have not closed gaps on. This is a very common sense bill. It would prevent police officers that are found guilty, which is a standard of beyond a reasonable doubt in a court of law, for a felony, perjury, or a misdemeanor related to truthfulness or veracity, from thereafter enjoying the pension benefits under the state retirement and pension system or a local retirement and pension system. The bill outlines procedural and substantive processes by which these benefits become forfeited. Currently, police officers acting under color of law commit serious crimes within the scope and course of their duties, but continue to be able to collect their benefits, including their pensions. This bill causes the forfeiture of those benefits when a law enforcement officer commits certain disqualifying crimes. I want to give a couple of examples. A few months ago, some of us read in the paper about officer or former park ranger Michael Browning. He has not yet been convicted, but right now, as he sits in jail awaiting his trial, he's able to collect his $95,000 a year pension, because any officer that serves 15 years and reaches the age of 55 is then eligible for pension. According to the records I was able to collect between 2005 and 2016, there are only 190 officers in Maryland that this bill would impact if it were to affect them. But this bill doesn't affect them. This bill doesn't even affect Michael Browning, because this bill is prospective. Officers such as Wayne Jenkins, the head of the Gun Trace Task Force, there's nothing currently in law to prevent him from sitting in federal prison right now collecting a pension, even though he has been convicted of heinous crimes while on duty. There are some officers that didn't have 15 years in and they didn't reach the age of 55, so they weren't eligible for their pensions. So that this doesn't affect every single officer that commits terrible acts. But officers, again, that have served 15 years and reached the age of 55 are then able to collect their pensions no matter what heinous crime they are found guilty of beyond a reasonable doubt in a court of law. Baltimore City and other jurisdictions have paid millions of dollars to settle lawsuits as a result of criminal conduct by some officers. The officers, however, are allowed to collect their full pensions. This cannot and should not continue. Police officers should not be allowed to violate their oath, waste the training investment, betray the public trust, and then be rewarded with a state or local pension. It should not be lost on us that we legislators are subject to some of the most stringent pension forfeiture laws that exist. And in fact, this is nothing nearly as difficult or as stringent as our law, because this bill allows for consideration of child support, alimony, and other familiar needs, children and spouses of convicted officers. We don't enjoy such a thing. So ostensibly, if one of us were to be convicted of a crime while serving in office and we were married and this were our only income, our spouses and children would be completely out of luck because they'd be able to enjoy no benefits of our pension. Our pension's forfeited. So this bill is much less stringent than what we would even endure. And I would also offer to this committee that even though we have the most stringent pension forfeiture law that exists, I have not seen a chilling effect on people wanting to run for office and serve in this body. So I believe arguments that this would deter officers across this state and agencies are already struggling to recruit and retain officers from doing so. I don't think any of us believes that we won't run for office on the off chance we commit a felony or a terrible act, and then we'll lose our pension. That's simply not a consideration. It is not a consideration for officers that we want on the force. We want officers that don't anticipate committing a terrible crime and losing a pension. We want officers that believe they're going to serve with integrity, honor, and commit no heinous crimes and do become a benefit to the public and a benefit to these agencies. And guess what? Once that is really restored, there will be no difficulty recruiting and retaining officers. Part of the arguments that we will hear from opposition about low morale because these terrible bills we've passed that require accountability and transparency are simply red herrings, because no officer that we want to serve in this state is going to not apply, because if they commit a felony, rape, murder, or perjury, they will then lose their pension. That is simply a non-issue. And I think it's important that we note that. Under this bill, I've already talked about the fact that spouses can recover. So I'll just finally say that this bill is one of the most thoughtful bills, thanks to the drafter who is here. One of the most thoughtful bills in the world. A lot of work has gone into it. It takes into consideration a number of things, including if a conviction is overturned, officers may have their benefits restored. 26 other states have laws that allow for the pension forfeiture for police officers that are either convicted or plead no contest, which is still convicted for unlawful killing. It's time for Maryland to do likewise. Police officers should not be allowed to commit horrible crimes and then enjoy the benefits of their pensions. This bill accounts only for the amount that the government, that the state has contributed that would be recovered. So this is really doing a service to our constituents, our taxpayers, to say that you don't have to pay for these pensions of these officers that commit these crimes. It does not affect the money that the officer would put in the officer's self. So I think it's important that we pass this legislation to show that we're serious. It's a parity bill because, like I've said, our government actors and legislators, our highest state officials, are subject to this. And I think it's an important message, but it's also, frankly, just a fiscally responsible bill. So with that, I'm happy to take questions. And of course, I would ask if there's anything specifically on pensions. There might be Ms. Gothrop or someone else, Mr. Anthony, that might be better able to answer the question.
All right, thank you, Senator. Any questions or comments from the committee? Senator Bailey.
Thank you, Senator, for bringing this legislation forward. Couple quick questions. When we talk about taking things away from people that were entitled and they thought they were getting their state pension, does this legislation involve anyone other than police?
This bill only affects law enforcement officers, but like I've said, others are subjected to this, such as us.
So the judges, are they subjected to this?
Not that I'm aware of.
So no matter what heinous crime a judge would commit, he would still get his pension?
I believe so.
How about?
Well, I don't, so, I'm not going to always say yes, because let me explain. Under law, there's nothing that would require that the judge would give it up. But as we know, a lot of people, including judges, may take a plea deal, and as part of their plea deal, they can always agree to step down and forfeit their pension, but it's not a mandated thing in law.
It's not mandatory.
Mm-mm.
Right.
No.
And so other than the thing that you talked about for legislators, does this exist for any other state employees?
I don't believe it does. Like I said, the highest the government officials exist for, but that's in Maryland. And I would say Maryland's behind the 26 other states that already have enacted these kinds of laws.
Thank you.
Thank you.
Any other comments or questions from the committee? Thank you, Senator, bringing the
Thank
bill
you.
up. I think we have some testimony from those who are against the bill. You don't have anyone else.
I don't,
In
I
favor.
could, well, again, this is the, like, really quickly, like so many bills, this is a bill that I initially sponsored when I was in the House of Delegates, maybe more than a decade ago. And last year, I did have Comptroller Bill Henry from Baltimore City, and some other retired law enforcement officials. I think the former Chair Elfrith was presiding over this then. I'm just saying, like, this bill is highly supported. We have very stringent sign up law, rules the day before, and that did preclude some of my potential witnesses for today. But the bill is heavily supported.
Well,
Just-
as you,
and
well, as you know, we will deliberate, so you have time to get some written testimony in, so.
Thank you.
All right, thank you. All right, we have a panel of those who are against the bill. For those, let me read the names. Carl Skinner. Andrea Mansfield, I'm sorry, that's in writing only. I know the FOP attorney is in court this morning, so we have Clyde Boatwright and Rebecca Smith. Am I missing anyone else who signed up? Is that it? All right, you all may proceed. Please state your name and organization. You have 2 minutes each. Thank you.
Good morning, Chairman Jackson, members of the committee. My name is Carl Schinner. I'm the first vice president of the Maryland Chiefs of Police Association, and we're requesting an unfavorable report on Senate Bill 597. Maryland Chiefs of Police Association strongly opposes this bill. Maryland law enforcement agencies across the state are and continue to have problems recruiting and retaining qualified law enforcement officers. Measures such as this will deter qualified individuals from having the desire to entering or staying in this profession. In turn, a shortage of qualified officers will lead to community safety issues, make it difficult to provide protection for victims and to properly investigate crimes. The word vested is an important terminology in retirement programs. Vested means secured in one's possession or assigned to a person. When an individual enters into a retirement system, they are entering into an agreement with the Maryland State Retirement and Pension System or other local system. As a government employee invested into its pensions under the agreement and upon meeting the working conditions, they are in return receive a benefit. The property and the accompanying benefits are the property of the investor and the employee earned over an extended amount of time. The forfeiture of this earned property amounts to a seizure by the government. The pension benefits that have been earned throughout the officer's public service career are contractually obligated as prior benefits similar to an IRA and are equally crucial to the officer's spouse or partner, and any dependent children. In fact, this provision, a spouse, partner, or dependent children would have to petition a panel to justify why they should remain or they should maintain the pension and benefit. I would like to reinforce that through these difficult times of recruiting and retaining qualified officers, the attempt to forfeit an officer's vested pension and retirement benefits provide an incredible disincentive for individuals to want to enter and remain in this profession, especially when they see that it is just law enforcement being carved out in this legislation. For these reasons, the Maryland Chiefs of Police Association opposes Senate Bill 597 and urges an unfavorable committee report.
Thank you, Chief.
Thank you, sir.
And we will hold questions and comments until the entire panel has concluded. So next.
Good morning, Mr. Chair, members of the committee. My name is Clyde Boatwright. I'm the president of the Maryland State Fraternal Order Police, representing 21,000 police officers throughout the state of Maryland. And I stand before you today, or sitting before you today, asking and urging for an unfavorable report for Senate Bill 597. In the state of Maryland, we have a recruitment problem. That's one of the things that everyone talks about. But going along with the recruitment problem, we also have a retention problem. We have institutional knowledge of police officers who have gained the trust of their community over time, deciding that this career field is no longer in the best interest of themselves and or their family because of legislation similar to this. We just went through historic police reform 2 years ago. To make holding those officers who violate the public trust accountable. And this body, the FOP, was a partner in making sure that we shape that legislation in the best interest of Marylanders. We have been a partner. We will continue to be a partner, but we think that this type of legislation, because our officers are watching, and as the chief said, there is no incentive for a young person just graduating from college to decide that law enforcement is the career field for them. Because if, years down the line, after you're vested, you got to, and it's hard trying to sell young people on this career field, because at every turn, when they turn on the news, it's about another way that a police officer can either go to jail or have their benefits taken. So I know we have 2 minutes, but in the real world, we are seeing historic levels of people just not joining the profession. We don't have a bullpen. To use a baseball term. These contracts that our local jurisdictions enter into with our police departments and our officers are just that. As Chief said, it's a contract. Once you're vested, you expect to get that benefit, and we're not seeing that in any other profession. So I'll be happy to stand for any questions, and I thank you for your attention on this bill.
Thank you. Next.
Good morning, Chair, members of the committee. My name is Rebecca Smith. I am General Counsel for the Maryland Troopers Association, and we are asking for an unfavorable report on this bill. I think it's been made clear there is a serious issue with retention and recruitment, so much so that the legislation this year included creation of a work group to try to find out why people don't want to be police officers. And these bills should be prime example number one for this work group when it's created. This bill clearly targets police officers, no other members of the Maryland State Retirement and Pension System or any local retirement system. Pensions are part of compensation that is earned. It is not a perk of employment that should be taken away. This bill could take money that has been earned and relied upon when these people choose this profession. That is something that is considered when people decide whether to become law enforcement or not. This bill would require forfeiture of money that may not even be tied to any crime for which the officer is convicted. Police officers are a very unique profession, and they are faced with a lot of obstacles when dealing with the public, and there should not be any forfeiture of any benefits earned. In this situation where a forfeiture would occur, under the new law that passed 2 years ago, we have an officer that is already criminally charged, already suspended without pay pending the criminal charges, and likely terminated without a trial board. They've already been punished, and now we're adding this extra step of a forfeiture of a pension. Who's going to support this person and their family? The taxpayers may ultimately end up supporting them because they're going to have no income. Spouses and the children should not suffer from the lack of financial support that these pensions could provide. Now, the officer or their spouse or child could petition the court within a year for a partial payment of the forfeited retirement. A partial payment that would be left to the discretion of a judge who, under the law, is given very ambiguous factors to consider when making this determination. So even though there's this outlet for families to receive the pension, it's a partial payment. It is still not going to keep the families and children from suffering. So with this, we ask for an unfavorable report, and we're happy to answer any questions.
Thank you. Questions or comments from the panel? from the committee? Senator Bailey.
Thank you all for coming. Thank you for the people that you represent. I appreciate it. I just had a few questions just to clarify the fact that you were here today and your support. Do any of you support the corruption or bad or illegal police officers or their activity?
Absolutely not.
No, sir.
Right.
No.
So is your opposition here any way tied to supporting any person of those 100 people that that the sponsor talked about that potentially would have been affected by this bill?
Absolutely not.
No, sir.
Mr. Boatright, how many certified officers FOP members did you say that you supported?
21,000.
And that doesn't cover all the police officers in Maryland. There's other people that are not FOP members, correct?
That's correct.
So there's well over 20-some thousand that are certified. Are you familiar with how many retired police officers there are in Maryland?
So we have about 17,000 active police officers, about 4,000 retirees.
But it would be fair to say that about 1,000 police officers retire every year and go on to live here.
Oh, yes, absolutely.
Right. So there's 30, 40, 50,000. And from what we heard with the sponsor, there's around 100 people that would have been affected out of all of those. Is it fair to impose this, if I hear your testimony, is it fair to impose this on 50,000 people as a coming in that affects your retention when we don't do it to any other state employees?
That is not fair.
Thank you.
Any other questions or comments from the committee? Thank you all for coming down.
Thank you, sir.
Thank you for your time.
Thank you. This concludes the hearing for Senate Bill 597. Colleagues, we are done with our hearing for this morning. If you look in your packet, we have 7 bills for consideration, for discussion. And I will turn it over to our analysts.
Thank you, Mr. Chair. The first bill we have is Senate Bill 274. This was a joint committee on pensions bill. You do have a reprint for this one on your desk. As introduced, this bill was clarifying the return of accumulated contributions for non-vested members. It was conforming the law to the existing practice. At the hearing, if you recall, the agency testified that there were a few additional pieces that did not get sorted out in time for the joint committee process, and they'd like those to be considered as additions to this bill. So that's what this reprint represents. So if you go to page 2 of the reprint, so last year there was legislation regarding immediate vesting for certain executive branch heads of units. That had been a longstanding provision. And last year there was legislation clarifying certain other positions where there was some ambiguity about that. This amendment would just be clarifying that. So it's basically listing out. So these are the agency and unit heads that the system has recognized were eligible for the immediate vesting, and including the positions that were added last year by legislation. So these are non-substantive changes. It just makes it more clear for everybody, so that they don't have to, every time you have a new person come in, there's a question. It's just, this provides certainty for those positions. And then turning to page 3, this is a new section. This is addressing an issue where there were some retroactive salary increases done. I believe this was some school systems had done this. And this is language just clarifying that those retroactive payments are not pensionable, meaning that there's no associated back employee contribution or employer contribution. Going forward, they'll be part of the salary, just like any other compensation.
Thank you. Any discussion? Any questions for our analysts? If not, a motion?
Second.
Any other discussion? All in favor? Any opposed? Thank you. Next, Senate Bill 368.
Senate Bill 368. This is a bill that would it'd be enabling legislation for emergency medical technicians to become participating governmental units in the law enforcement officers pension system. System has reviewed this. The EMT function is the tax council's fine with their participation in LEOPS. Again, this is enabling, and just to be clear, this is similar to paramedics and firefighters. This is just for paid EMTs, not volunteers, because you need to be paid to be a member of the system.
All in favor? Any opposed? Thank you. Are you opposed?
Entertain being a co-sponsor.
Okay, can we back up?
Mhm.
All right, any other members who'd like to be co-sponsor on this piece of legislation? 368. Senator Benson, are you interested in being a co-sponsor?
Yes.
Thank you. So it's everybody.
Is that everybody? Okay.
Yeah. Thank you all. I think that's a good bill.
Senate Bill 369, this is Joint Committee on Pensions legislation. This is some follow-up to the bills in the past few years about adding certain employment functions into the correctional officer system. The first thing the bill does is, you'll find this on page 3. Last year, it was inadvertently omitted to provide for the members that were added as of 2022. We also, whenever people are moved, we have provisions allowing for the calculation of their sick leave to be included. It's because they're potentially straddling or moving systems. And generally sick leave is only going to be calculated from the system you're in. So this allows the full sick leave to be considered because they're being moved in. And then the second part of the bill is, so after all of these moves have been happening, the initial process was everybody had to be moved in. There's IRS constraints about giving people an option. So we had to move everybody in, but then they had the option under existing law and in the bills to transfer their employee system time into the correctional officer system. There were a number of employees who did not do that. And the system at the Joint Committee had testified that what was going on is some of the members would have deficiencies based on their contributions because of the different contribution rates between cores and the employee system. And there was a little bit of sticker shock. The system went through and in every instance, even with a deficiency, some as high as close to 6 figures, that gets spread out over your lifetime. And in every instance, the review that the agency went through, it was always to the benefit of the member to move their time from the employee system into cores. And so what the bill does, second half of the bill in the uncodified provision, for all the people who hadn't done that, because some of them are past their window to make that transfer request, it moves their time in by the end of it's June 30, 2024. And it gives them an option to reach out to the system and say, actually, no, I really don't want to move my time in. So it gives them an opt out from being moved in, but generally it's going to move everyone's time into cores because it's always going to be to their benefit.
All in favor? Any opposed? Thank you all.
All right. Next bill is Senate Bill 395. As introduced, this bill would have been corrective legislation for an issue that arose with some employees for Historic St. Mary's Commission. There were employees that were improperly enrolled in the optional retirement program. That was corrected and they're put into the employees pension system. And the issue is that ORP service is not being considered for the determination of their eligibility for retiree health. You do have a reprint on your desk. There was some discussion at that hearing about taking a broader look at this and fixing the issue where when you're retiring from the system or the optional plan, consider all of your state service. Because some people, especially, this has come up a number of times over the years. It more commonly comes up in the ORP because you'll have people that have pension system and ORP service. And what happens is you may have somebody who has 20 years of service, but they only have 10 or 12 in the system that they're retiring from. And that other state service is not being counted towards the eligibility for the retiree health. So the reprint before you effectively strikes the bill as introduced. And then if you turn to page 3, so the uncodified provision, which was the meat of the bill, is introduced. That's being stricken because these amendments should cover those individuals. And basically what the change is, we're doing it through definition. So we're clarifying that creditable service, which is what they're adding up to determine your eligibility for both participating in retiree health and then also your subsidy. We're stating that that's any period during which an individual was employed by any of the 3 branches of state government and enrolled in, so 2508, this is for retirees of one of the pensions or retirement systems. So any state service, whether it be in one of the pension systems or in the optional retirement program, because those are the 2 retirement systems you'd be retiring from, all of that service would be considered for determining your eligibility for retiree health. And then on page 6, you have section 2509. This is the provision dealing with the optional retirement program. And we have similar language mirroring that. This only references being a member of one of the several systems under Division 2, because this provision is about being in the ORP. So it should have the same effect. It refers back to the eligibility under 2508 for other state employees retiring from one of the pension systems. So in totality, whether you're retiring from one of the state plans or the optional retirement plan, all of your state service, whether or not it's attributable to the benefit you're drawing, is going to be considered.
Senator Alford, 1 second. This is something that's my 9th year in the legislature, and I think me and Ms. Gothrop have become quite good friends because we continue to run into these matters. Our system throughout our state, we have so many pockets of systems, and we're doing a disservice to our folks. So a study is warranted. Philip, on page 3, you wrote amends should cover these affected employees and UMB affected employees.
University of Maryland, Baltimore had reached out to me. They had, when this bill was introduced, they had found some other individuals in the optional retirement program who were experiencing a similar issue where they're in the ORP and they have pension service where it's kind of the inverse of the St. Mary's Commission people. They're in ORP, they were improperly enrolled in the pension system.
Right.
Similar to the universe of employees for the bill is introduced, these amendments should cover all of those instances because it's more broadly addressing the issue.
Got you. Senator Alford.
Thank you, Mr. Chair. Similarly, 5 years on this subcommittee, and this issue seems to come up at least once a year. And I think at the heart, our job is about measuring balance and fairness, and state service should be state service when it comes to this
Absolutely.
benefit. So I would move the amendment and the bill as amended favorably.
Second, all in favor? Any opposed? Thank you all.
All right, next bill, Senate Bill 454. Bear with me, it's complicated, but not really. So it's following the rule.
Is that Senator Alford's?
So when somebody retires from any of our pension systems, they have the opportunity to, so when you retire, you have your average final compensation, you have your years of service, and you have your plan multiplier. That determines your basic allowance. So you can retire and just take that and you get it for as long as you live. When you die, that's it. So for most plans, people, when they retire, if they have a spouse or some other person they want to provide benefit for, they can select an optional benefit that provides for benefit past their death to somebody else. Usually it's a spouse, but it can be anyone else depending on which option you're selecting. When you do that, there's generally going to be a reduction in your basic allowance. And the reason for that is that it's reflecting that instead of the expectation of one life being paid out, you now generally are going to have a longer potential payout timeline because it's going to be the latter death of one of two people. In the state police, law enforcement officers plan, and the judges system, there is a different feature where there is an automatic survivor benefit for spouses when somebody in those plans retires, if they're married when they retire, they don't get to take an option and they get their basic allowance. And then when they die, their spouse gets a percentage of their allowance. So the difference there is that there's no reduction to the basic allowance, like in the employees and teachers and corps plans. So the issue this bill is addressing is that prior to same-sex marriage being legalized in Maryland, if you were a member of one of those three plans, you could provide your partner or spouse, even if the state wasn't recognized at the time, you could provide your spouse with a survivor benefit, but to do that, you would have to go through the route of taking a reduced pension to provide that survivor benefit. This came to our attention because Anne Arundel County actually had passed something. And so what the bill does is for those three plans, it provides a method to go back and fix this issue. And so if you have a retiree prior to same-sex marriage being legalized who had selected a beneficiary and then later married that beneficiary, it allows those affected people to come back and the bill would restore the baseline benefit that's already in law and then also provide a retroactive lump sum for the difference in what they should have been paid. So the difference between the basic allowance and then however much their allowance was reduced to provide that survivor benefit. So at its heart, it's providing parity for retirees in same-sex relationships who did not have the opportunity to get that automatic survivor benefit because the state did not recognize a marriage in that situation.
So Philip, is there a window?
There is a window. I think year on this one. Yeah, so this it would take effect July 1. The affected individuals would have the opportunity to reach out to the system, and because it's not gonna be a very uniform process. It's gonna be dependent on, you know, when they retired, who the beneficiary was, things like that, and how long they've been retired. So like, it also provides protections in the event that you had somebody retire and they've since died, but were married before. So I think we've covered all of the iterations, you know, but we've left the bill open for a year. Normally on these, it's a 6-month window. Right. The bill here is left open for a year in anticipation, just in case there's a more unique circumstance of a retiree and their spouse. It will be open so that you can make a fix next year if you need to accommodate that.
Senator Elkins. Is it clear to you?
Do you have any amendments?
No amendments.
No amendments? Okay, second. Everybody looks like they're right on point with this. Are we good with this? Ms. Gothard, would you like to take a shot at this, or did Philip do us justice?
The agency appreciates staff reaching out to us when they were drafting the bill. We didn't notice the bill at all.
Thank you. All right. All in favor? Any opposed? 2? Okay. All right. What does that mean? All right, 4. 1 second. Does that mean? Are we good?
Yeah.
Okay.
4-2.
All right, cool. 466, Senate Bill 466.
466, this is a joint committee on pensions bill. This is the bill that is updating the amortization policy. So currently we have a closed 25-year amortization policy. We're reaching the point where more volatility is expected to affect the employer contribution rates. So every year we move through that closed system, we have 1 year less to make up and spread out any losses. So what the bill does is recommended by the Joint Committee on Pensions. We worked on this with the systems actuary, your legislative actuary, and the Joint Committee. This is basically model policy for the actuarial standards. Now, there are some technical amendments. You'll see those on page 2. We're changing 2038 to 2039. This is actually an error in the original legislation. The 25-year period, actually 2039 would have been the appropriate date. So for keeping the current timeline for the existing liabilities, that's the appropriate date for that. Down on lines 3 and 4, just additional clarifying that these new periods of amortization are closed. So it's a layered closed amortization policy. So every year a liability, you'll have a 15-year window. The next year you'll have 15 years. The prior year will have 14 left, and each one will run down. So this provides more transparency in terms of the sources of each liability. And then lines 10 through 11. At times, the state has done incentives for early retirement. Back in the Great Recession, this was done. It was intended to kind of get some savings by having longer term employees retire, and then you can recycle with newer hires. This is just clarifying that that's what this 5-year window is referring to. It's not referring to an early retirement, which is a feature of some of the plans where you can take an early retirement at a reduced benefit. That's not what that's referring to.
All right. Any questions or comments? Need a motion? All in favor? Any opposed? Good. Thank you. Last bill.
All right. So this last bill was dealing with an issue for non-vested accounts when somebody comes back to work. So if you're a member of one of the plans and you don't vest, after you leave service, your account will continue to gain interest for your membership period, which is generally 4 years after you've separated from service. You can always request that money to be distributed to you. So generally you'd ask for it back, you'd roll it over into something so you wouldn't take a tax penalty. The issue for the affected individuals under this bill is that if you come back to a position with a participating employer, the system can't return your funds to you from that old account because it would be considered an in-service distribution, which is something you can't do under IRS rules. And so what happens is those accounts, they stop earning interest after 4 years. And so they effectively just sit dead. It's a pot of money that's not earning any money. When the member retires or leaves service, they can get the money back. But in that intervening time, it's not earning any interest. And so what the bill does is previously this had been done kind of more targeted for individuals for the pre-reform and coming back into the reform system. This bill makes the change for all the systems. So if you have a non-vested account and you're reemployed in any of the other systems, that non-vested account will earn interest while you're reemployed. There's one technical change. As drafted, the bill did not cover the teachers' retirement and pension systems. So on pages 2, you'll see those changes where we're adding them back in. And then on bottom of page 2 and on to page 3, we just consolidated some of the provisions to make them clear and then remove some redundant language. There is one other piece on this bill. So if you go to the end, at the hearing, there was question about how the bill would apply, whether it be prospective from the effective date of the bill, or whether it would be retroactive for anybody back to the date when they resumed employment. The bill in 2018 did have a retroactive provision. So if anyone was in a position or employed on the effective date of the bill and they had one of these accounts, these debt accounts, the interest would go back to the date that they resumed the employment. So I think I got an estimate, the cost on that, the potential universe of non-vesteds is about a little about $500,000 for that retroactive interest to those accounts. But again, that would, I don't have any info on how that would be spread in terms of affecting contribution rates or anything like that. But it's a fairly small universe. I think it's around 1,500 potential accounts.
So go back to the date they resumed.
It would, yeah, the retroactive piece in 2018, the way it worked is if you were an employee in one of the systems on the date the bill took effect,
Came back into service, it would go back.
and you had one of these accounts, the interest would go back to when you effectively became reemployed. It's not really a reemployment issue, but when you resumed employment with a participating government unit, that's when your interest would kind of be retroactively applied
Okay,
up through the effective date of the bill, and then going forward, it would just earn interest like an active account.
sound good to you, Ms. Gothard?
Reiterate what Philip said. In the spirit of full disclosure from the agency, that we determined the whole pool that this would affect. And that the interest that we owe for the retroactive piece is a little over $500,000. But going forward, if you do it retroactive, it could increase the cost going forward because you've already added interest that was past due. And so it accumulates. It accumulates. Compounds. That's the word I'm looking for. Thank you. It compounds. So it's already, by giving the retroactive piece, you've already compounded however many years that person has worked. We have no position on this. We think, this is a good bill. It's doing what it did in 2018. If you want to do it retroactive, that's great. If you don't, that's great. Just be aware of, we just want to make sure you have all the facts from us before you make your decision.
Thank you. Any other questions or comments, anyone? So seeing that typically the pension chair is the floor leader, you'll probably be receiving calls, both of you, as we move forward. Do we have a motion for Senate Bill 481? All right, all in favor? Any opposed? Good. That concludes our.
Is that with the retroactive piece or?
I'm sorry. So is that an amendment?
The amendment before you does not include the retroactive piece. I know I flagged it for discussion. So
I'm sorry.
the amendment before you does the technical fix for the teacher system. There was the additional question. You can do that by concept. I can have that ready for full committee if that's the subcommittee as well. Okay.
So are you? Okay, this is the motion has been amended to include the retroactive piece, so.
And then Senator Benson, you wanted to be on it?
Yeah.
Okay. Anybody else?
Any other co-sponsors? All right, all in favor? Any opposed? We're good. Did we do that right?
Yep.
All right, that concludes our hearing this morning. And we'll be in touch by our next session.
Yep, 16th, next meeting, I'll be in touch.